Yes, it is that time of the week. David Whiting has sashayed into the studio to answer all your questions on the legal front. David Whiting, good morning.
Good morning, Ali.
1300 222 774 is the number, as if I have to tell you. Or you can text, but much better if you call and talk to David. But 1300 222 774 or 0437 774 774. Now, David, you had some homework.
Yeah, I had a caller last week ringing on behalf of a friend. Sometimes that makes life difficult, but in this particular case, the friend lived in a country town, owned a block of land next door to her house, and somebody had abandoned a car there. And I started talking about the disposal of uncollected goods or unclaimed goods. And I said that I would go off and do some research, and I found out the advice I gave last week was broadly wrong. There's a concept called uncollected goods or unclaimed goods, and that's where goods are left with you for a purpose.
Dry cleaning, for example?
Yeah, dry cleaning or a car for repairs, those kinds of things. And at law, that's called a bailment. And uncollected goods only arise in circumstances of a bailment. And the person who's got possession of the goods then has three different methods of dealing with the goods that are uncollected, and it basically depends on their value. So low value is under 200, medium value is under 5,000, and high value is over 5,000. And there's a set of rules as to what you do and how you deal with it. And the Consumer Affairs website's fantastic in terms of stepped process. But these are abandoned goods. There's no concept of bailment. I simply dump my car on your front lawn and do a runner. You have no idea where I am. What can you do about it?
You've never met me.
Yes.
There was no contract between us, nothing.
Yes, so there's no bailment in that situation. And the advice that John and I'm going to say John gave the advice, but I didn't dispute the advice, was that you
Blame him, he's not here. He's miles away.
You never know, he could be monitoring, is that you push the car out into the street because there is a process under the Local Government Act that allows council to impound these goods. There is also a provision in the Road Safety Act that I found that if there is an abandoned motor vehicle, the Chief Commissioner has the power to impound it and sell it and keep the money. Whether you would be able to persuade the police that they ought deal, in this particular case it was a 20-year-old Holden, probably worth somewhere in the hundreds of dollars. Whether you'd ever be able to persuade the police that it was an appropriate allocation of their resources to impound a vehicle, I would worry.
So would you go back to the old advice?
I would
Just
go
push
back
it out
to the
onto
old
the
advice
street?
and say to the Victorian Government that the Western Australian Government actually has a piece of legislation that deals with what you do with abandoned goods. So I suggest that they might look at that and see if that works.
Yeah, good.
Now, and I have one bit of news, and that's a High Court case that was started a couple of weeks ago, and the question revolves around whether sperm donors have rights as parents. Now, this is a sperm donor in New South Wales. There's a piece of legislation in New South Wales that says that a sperm donor is presumed not to be a father of the child unless married to or in a de facto relationship with the mother at the time of conception. Right? Now, the family courts actually considered this before and effectively said that if the conception occurs other than as a consequence of intercourse, then you're not the father. It's you're a donor of sperm, but you're not the father. So in this particular case, filed by a Newcastle man who donated sperm to a long-term friend and has been actively involved in his daughter's life. Changed nappies, soothed her in the night, attended school and daycare events, and in accordance with the note that I've got, did a mean ballet bun. Well, clearly wanted to be involved. Question arose where the mother wanted to move to New Zealand. And if the father had parental rights, then you either need consent or you need the court to dispense with consent. He won before a single judge, where they said you've got the rights of the father, lost in the family court appeals system, and is now gone to the High Court. And so the High Court now needs to decide whether sperm donors who intend to be involved in fathers and are known to their biological offspring as dads should be recognised as legal parents.
That's fascinating. So how does that work in the case of IVF, for example, if in fact conception doesn't arise from intercourse, however, the donor is in fact the biological father?
Well, you're the biological father as a result of the conception, right? Whether there's intercourse or no intercourse. What we're really talking about is what rights do we give to the person who's the donor? And the answer is almost none, but certainly not the right of the parent.
Except in this case.
No, well, yeah. This case says, look, I'm involved. I'm around. I mean, it's like somebody might donate or give sperm to a friend, and have nothing more to do with it, or might donate sperm and then have an involvement in the child's life, and that's where we are here.
Fascinating conversation. 1300 222 774 is the number. Peter in Mount Dandenong. Good morning, Peter.
Oh, good morning. Thanks for taking the call.
What did you want? Peter. Yes, fire away.
Right. Yes, there's a strip of Crown land next to my property, just a little strip. It's sort of a track that's not used for anything. I want to gain access to that strip in order to put a pipe down, in order to get water down to my place from the mains on the main road. And I've applied to the
relevant department,
the Minister for access to this.
Yes.
Under Section 235 of the Water Act. And Section 235 says that the Minister must appoint an authority to determine the matter if an application is made. And I've done that back in February.
Yes.
And the Minister wrote back to me saying no, and that particular act does not bind the Crown. And but anyway, I think the reasons she supplied were just not logical or coherent. And I'm just wondering where I can go from here. So the question is, how do I compel the Minister to do something that an Act says that she must do if she simply doesn't want to do it?
Supreme Court proceedings it's called mandamus, where you say this is a mandatory exercise of your power. You must appoint an authority to determine the issue. Having said that, though, Peter, there's no guarantee that the authority will determine in your favour.
Oh, I understand that. Yes, that's all. But all I want is this opportunity to sort of plead my case before the authority and have it decided by the authority. The problem with the Supreme Court, as I understand it, is that I'd be up against a platoon of QCs, and if I lose,
well, at least one, yes.
And if I lose, I'd be up for paying $50,000 in QC fees.
My view is the bill would be higher.
Yeah,
substantially higher.
So unfortunately, that's just not a practical option for me. The Supreme Court option. I just want.
Have you raised the matter with the Ombudsman?
I have. They don't have any jurisdiction to compel the Minister to do anything.
No, that was always going to be a problem, but they may have some. Have you spoken to your Member of Parliament?
Oh, yes, I have. He washed his hands of it. Had no interest. I've written to him a couple of times asking him please to lobby the
to
Minister.
Intercede on your behalf with the Minister.
Beg your pardon?
To intercede on your behalf with the Minister.
Yes, just to have a quiet conversation with the Minister on behalf of...
Well, I can understand the embarrassment if you were to run the action in the Supreme Court before... I mean, who knows? There might be a change of water minister at the election.
Yes.
Which has got to be in November. There may not be. We just don't know.
Yes.
So, and you're not going to get to the Supreme Court before November anyway.
Yes.
So, apart from the Supreme Court proceeding... I think you're being
advised to keep your fingers crossed.
Well, no, yeah, that's Peter's view.
The other element is there was actually a VCAT hearing in September last year.
Yes.
And VCAT said they did not have jurisdiction to compel the Minister. However, during the course of the hearing, the member confirmed that I may apply to the Minister. So that's an absolute confirmation from VCAT, although it didn't actually take the form of a declaration.
Well, no, so you've got the right to apply to the Minister, and it's just the Minister is refusing to act.
The Minister does not acknowledge that I have the right to apply to the Minister. The Minister says the Crown is not bound, which is just completely specious and silly.
Sorry, in terms of the conversation we're having, Peter, I don't think I can take it any further than that.
Yes.
If you believe it's a mandatory, then write to the Premier.
Premier, okay.
All right, Peter, good luck with that.
Very much.
Andrew in Kew. Hi, Andrew.
Oh, hi, David. Hello.
Andrew.
I just have a query about police powers. Last week there was a crane damaged in Richmond, and it was reported that 300 people were evacuated from their homes.
I think that sounded truly horrible. Knocking on the door, waking up 300 people. And, the Richmond Town Hall is fine for a party, but I wouldn't want to have to spend the night there.
Andrew, were you one of them? Were you?
No, I wasn't, but I was just, my query is, do the police have the right to come onto your property and evacuate you from your home? Or do they just recommend that it's a good idea to get out?
I'm going to take that on notice, Andrew. I'm back in a fortnight. I'll let you know then.
Okay.
I certainly know that they don't do it if they don't think it's worthwhile and appropriate, but that's not quite the same as what you're asking.
Well, what I'm asking is, can you just say, well, thanks for telling me very much, but I'm staying here?
That's a question. That's a question I'll answer in a fortnight.
All right, Andrew, so hold your fire and tune in 2 weeks. Joy in Brighton. Hi, Joy.
Yes, this is about a householder's public liability policy.
Yes.
I wondered if it only applies to the titled land if you have someone working on your property. Now, in the case of a dog walker, they go out onto the footpath and nature strip, and I wondered if you're covered for a dog walker.
The nature strip's not is it your dog walker or some other dog walker?
No, it's our dog walker. We frequently need to use a dog walker.
There's two parts to that question. You may have a responsibility. So you look at what is called the product disclosure statement for your house insurance, and the public liability element relates only to your property. You don't own the nature strip. So from a public liability, there's no issue. What you might like to do, though, is see in your policy whether you have any liability or any cover for liability that you may have to contractors or people who are your employees. So somebody who comes and does the house cleaning, for example, you will have some degree of cover under the work cover legislation, depending, of course, on what your total wages bill is. But in terms of if you hired a dog walker and your dog bit the dog walker, you may have a responsibility. But if the dog walker took your dog and stumbled, then I don't see that you would have a responsibility. They would normally be seen as independent contractors.
Right. It's just that this dog hates cats. It's a whippet, a sighthound.
Yes.
And it goes crazy instantaneously when it sees a cat.
Yes.
And my husband and I we're 80, and we've both had falls due to the dog, but no injuries so far. But my query is that if the dog walker fell and broke a hip or a back or something, whether we'd be liable.
If you advised the dog walker of the inherent problem with the dog, then I don't see you would have any liability to the dog walker.
Joy, that sounds like the best advice. Just make sure that they're well aware of the sort of dog that they are walking. Steve in Stawell. Hi, Steve.
Good morning, guys. How are you going?
Good.
Good, thanks.
That's good. Sorry, now reception of you is not the best, so I might drop out. Are you there?
Yes, indeed.
Yeah, we can hear you loud and clear.
Okay. I'm just calling in regards to a case there was a judgment made the other day regarding a con man in the county court.
Yes.
He lodged false documents against some people who didn't know that they were being taken to court. You're probably fully aware of that.
I am. There was a great story. It was written up really well on the ABC News site.
Yeah, I've got it here at the moment. What concerns me is the fact that he lodged false documents with the court.
Yes.
There was no verification of that information. To me, it just appears they accepted on face value. They proceeded with everything, or am I wrong in that?
Can I say, Steve, I think it's appropriate that they do accept it at face value. Where I'd look at it, so what's happened is that somebody issues proceedings against, let's say, Ali, I sue you. So I issue a proceeding saying that you owe me some money. I don't serve it on you, but I go along to the court and I file an affidavit that says I did serve it on you on this day at this time.
Yep.
You haven't entered a response or an appearance, so I get judgment against you. I then go off to the federal court and I issue a bankruptcy notice against you, and I do exactly the same thing. I don't serve it on you, but I tell the court I have served it on you. I then issue a creditor's petition. I tell the court I've served it on you, I haven't served it on you, and the next thing you know is you find that you've been declared bankrupt.
Yep.
So
Yep.
So what's your process, Steve?
Well, my process would be the fact that, okay, if someone says, look, you've had that served against you. I would have thought, and I obviously am wrong here in this case, is the fact that the courts would verify to sort of say, okay, we'll check with you to make sure that you have been served and it's going to proceed. And you can say, hang on, what's going on? I know nothing about it.
I can see a couple of, I suppose from the state's point of view, from the court's point of view, if there's one in $200,000 that is wrong, the cost of fixing the problem is incredibly high. The first thing you could do is you could come along and say, you're not allowed to serve your own proceedings, so you need to get someone else to serve it. That would go part the way to solve your problem.
Yeah.
The second way to do it would be to make the state responsible for the service of proceedings. I actually think that I don't see that the state's particularly efficient or effective at that. It's not something they've ever done well. So I wouldn't run at that. I think the way I would look at it is in the early stages is the response to the litigation would to say that you can't serve your own proceedings.
Yeah, I mean, it's just it's a frightening thing, the fact that this can proceed without someone sort of knowing, as the people have said.
Well, I understand.
They spent $100,000 restoring their financial status.
Yes.
Now, I mean, I'm not going to speak on behalf of these people who were at loss, but are they able to claim that back?
Yes, but from the man who's got no money and after he's done his time is likely to be deported.
So you're really stuck. Basically, you've made me bankrupt. I didn't know you were doing any of that, and it's going to cost me a fortune to get my status back.
Yes, but you can, if the courts will, in theory, send me to jail for doing it.
Yes, but that doesn't help me, does it?
No, but I'd be punished for the wrongdoing.
Gosh.
Steve, I take your point. The question is, at what point do you... Your other option, of course, is to say, I think the only way you could guarantee would be to make the state responsible for effecting service.
It's just a frightening concept, the fact that vindictive people out there can go to these links and it gets so far, the fact that people actually had to spend money of their own over $100,000.
I would, can I say, I know nothing more about the case other than what I read in the paper. But I do know that when judgments are entered against you in court, there are agencies that start writing you letters that say, a judgment's been entered against you. You're having problems with your debts. Can I help you with these things?
What sort of agencies?
There are there are credit reporting agencies that report internally if I was to sue you, but they would also report if I was to enter a judgment against you. They would get your name and your address from the summons, and they would then write you a letter and say, you're having trouble with your debts, you want some assistance with debt management.
So it might be hard to get to the whole point of bankruptcy.
Yeah, I would have thought very hard to get all that way.
With no knowledge. Just a text message here to help our lady who owns the Whippet. Get rid of the dog walker, get a dog trainer. Whippets are very trainable. There you go. You can stop your Whippet chasing cats, which seems to be a problem. Peter in Hurstbridge. Hi, Peter.
G'day,
Good
Peter.
morning, David. Wonderful program. Thank you very much.
Sure.
Can I ask a question in regards to a dirt road? We're a bit confused in here. I've been here about 20 years. It's listed as a government road.
Yes.
And we've always been under the impression that if it was ever to be sealed, that the government, like the state government, would be the one sealing it, unless we request
you're suffering under a misapprehension, Peter.
Please enlighten.
All right. The government road would inevitably be under the control of council. All right. Now, it might be under the control of Vic Roads or, we have a road. Some roads are controlled by council. Some roads are controlled by Vic Roads. And some roads are controlled by a government department who looks after what I'll call unused roads. So you see them a lot in the country, and what happens is that they were built as roads in a planning sense or set aside as roads 40, 50, 100 years ago. We now don't use them as roads, so what we do is we lease them to the man next door. So council says we don't require that strip of road as land. We don't require that strip of dirt for use as a road. So it stays designated as a road, but the government takes it back and leases it to an owner. Now, at the other end, there are roads where the state government takes control via Vic Roads. The roads in the middle are roads controlled by council, and council is responsible for maintenance at the level it wants to maintain them. If council decides that it wants to seal the road, then the process under the Local Government Act is a thing called a private street construction scheme. And council can construct the road in one of two ways. It can levy a special rate, and there's a messy process for that, or they can enter into a private street construction scheme where they come along and say, Steve, Peter, we're doing the road out the front of your property. Having regard to your frontage to the road, your share of the cost is this amount of money, and you're now going to pay it off on your rates for the next 20 years. Does that answer all your questions?
Gosh, I hope so.
Could you just clarify also, if the road is a Vic Road controlled road, is that any different at all in regards to sealing or not?
Well, given that the private street construction scheme process arises under the Local Government Act, if it's a Vic Roads road, I wouldn't expect you to be contributing to its cost. But they only take the major arterial roads.
Right, Peter, I'm going to leave that there. I think that's a fairly comprehensive analysis of the situation with roads. Jem in Mornington, let me just find you. Hi, Jem.
Hello. We've had a situation where we went to purchase a holiday home about 5 months ago. We put in a verbal offer and it was accepted by the owners of the home. We paid a $1,000 deposit and then nothing has happened since then, and we don't quite know what rights we have. The agent calls the people that own the home. Every month or so he gets in contact and the owner will be on a tuna fishing boat or somewhere else and is promising to get the paperwork through, but nothing's happened. So we just don't know.
Jem, you have nowhere to go.
Okay.
All right?
Yes.
Right. In order for a contract for the sale or purchase of land to be enforceable, it needs to be reduced to writing.
Okay.
Can she get her money back?
Oh, she get her money back. Yeah.
Yes, we can do
get
that.
Your money back, but you can't. You can't force. If the contract had been signed, you would be able to enforce it.
Okay.
The contract's not been signed.
Yes.
You therefore have nowhere to go.
Okay.
Sorry, Jem,
you so much.
Have to go looking for another holiday house. Henry in Kilmore. Hi, Henry.
Hi. Thanks for taking my call. David, I had a concrete tank poured on site. Yes. A large tank. And in the first 12 months it cracked.
Yes.
And I got in touch with the manufacturer and they came out and had a look at it and patched it up. Anyway, the year after when it filled again, because they had to empty it to fix it up.
How long ago, Henry, did you get it?
It was built in on the 13th of the 10th, 05. But there's a 30-year guarantee with it.
Yes.
Anyway, I got in touch with them the next year and I said, look, the tank's still leaking and what about, coming in having a look at it? And they said, yes, no worries, we'll come have a look, but we're a bit busy at the time, so just leave it with us and we'll come. Anyway, this went on for the rest of the year, and then
so where are we
winter
now,
came
Henry?
along and it filled up again
and leaked again.
And leaked again.
So where are we now?
Well, in the finish, he wouldn't take my call. I'd ring him up and he'd just let the phone ring out. Anyway,
Henry,
I thought I'd be pretty clever and I'd nick down the street and I'd ring from payphone. Well, he answered the phone straight away.
Yep.
And then he said, yes, we'll come and have a look, and nothing happened.
And what do you want to happen?
I decided I'll have to do something myself. So I got in touch with some concrete people and they said the best product you can use is this particular product and try that. So I attempted to repair the tank myself. So I cleaned it all out and put this stuff in, and it worked.
So, Henry, what's your question for David?
What do you want from me?
Well, it only lasted for a couple of years, and then it leaked again. So then I rang him again, and he said, yeah, we'll come and do it. This is about 10 years down the track.
Yes.
And we'd come and do it. Anyway...
We've still got 3 years to go, Henry. Cut to the chase.
Well, I want to know what I can do with it because it's still leaking.
Okay,
it's leaking about 150 gallons a week.
If you've got a 30-year warranty, you are able to go to VCAT to enforce the 30-year warranty. In terms of what you have said to me, I'm a little bit concerned because you might face the argument that the work that you undertook 5 years after acquiring the tank has made the situation worse and made repairs more difficult. But you have a 30-year warranty. You can commence proceedings within the 30 years. Go for your life. But I'd go to VCAT.
Good luck, Henry. Look, I just want to squeeze in one more. Ian in Eltham, if you can be quite quick with your question.
Yes, thanks for taking my call. I'm calling with regards to a pre-settlement inspection I went to with my daughter earlier this week on an apartment that was bought off the plan.
Yes.
Now, we took measurements of the apartment, and the advertised dimension of the apartment was 51 square meters, or 51 to 52 square meters,
Yes.
with a disclaimer down the bottom that it was an estimate.
Yes.
But the actual measurement, even after we allow for some, the width of the thickness of walls and etc., came up to only about 46 square meters. Now,
Wow.
do we have any...
You probably, I haven't seen your contract, Ian, you probably have the right to avoid, and they will have given you some plans that were said to be approximate. Most of the contracts that I see say that, and sorry, my first reaction would be, is that you probably only own the inside of the wall and what's inside the walls and no part of the wall, which would make it even smaller than 46. Most of the contracts that I see say that you agree that a variation of less than 5% does not count. So if they give you 95% of what you contracted to buy, you say that that's what you contracted to buy, pretty close, and you're locked in.
Yeah, the contract didn't have any kind of disclaimer, but
Okay.
it does have this disclaimer that says the contract is the contract to buy the apartment and does not rely on any materials you have been given prior to the signing of the contract.
I don't know that gets them anywhere, Ian, in what you've described. You have rights under the Sale of Land Act about Section Capital 9AA. So have a look at the Sale of Land Act. How much is your daughter paying for this?
About $450,000.
Yeah, well, it's really nice that you've got the utmost faith in me, Ian, but for $450,000, I wouldn't spend it on my advice alone. I'd go off and get some advice with the contract and tell them what your problem is.
Good luck, Ian. I mean, that's quite a difference, isn't it? You're measuring up and you've suddenly lost 5 square metres.
We've lost 10% of the property.
That's a lot. And just a quick text message here that says, I'm in the same boat as Peter. To seal our dirt road, we 20 residents have to pay personally, despite Vic Roads and the council maintaining the road.
Oh, yeah, but
That's
you
from
want to
Joanne
better.
and Berwick.
They'll maintain it, unless, of course, council says, no, we're going to upgrade the road whether you like it or not.
That's
That
entirely
happens
different.
too.
David Whiting, thank
Thank you, Ali.
Lovely to see you, David Whiting. There, you're not here next week, I
No,
understand.
I don't get the benefit of talking to Virginia next week, but I'll be talking to John the week after.
Excellent. David Whiting there, the man who answers all your legal questions on any and everything.